afternoon, and welcome to the Elections and Human Rights Discussion Series organized by the Institute for the Study of Human Rights. This event is co-sponsored by Columbia Votes, Columbia Law School's Human Rights Institute, Social Work Votes, and SEPA's Human Rights and Humanitarian Policy Program. Thank you to them and to all of you for joining us today. Today, I'm pleased to introduce our third panel in the series, Incarceration and Voting Rights. And we are joined today by Jennifer Holmes from the NAACP Legal Defense and Education Fund, Kevin Morris from Brennan Center's Voting Rights and Elections Program, Nicole Porter from the Sentencing Project, and Professor Bernard Harcourt. I will introduce him briefly and then turn it over to him. Bernard Harcourt is the Isidore and Seville Sulzbacher Professor of Law and Professor of Political Science at Columbia University. His most recent book, just published last month, is titled Critique and Practice, a Critical Philosophy of Illusions, Values, and Action. He began his legal career representing death row inmates, working with Brian Stevenson, and was now the Equal Justice Initiative in Montgomery, Alabama. He continues to represent pro bono inmates sentenced to death and life imprisonment without parole. In 2019, he was awarded the New York City Bar Association Norman Rudlett Capital Defense Distinguished Service Award for his work on behalf of individuals on death row. I would like to thank him and our panelists for joining us today, and I'll turn it over to you.
Thank you, Christina, and welcome everyone to this really important conversation about voting rights. We're thrilled to have an extraordinary panel of dedicated lawyers and scholars and researchers who are really focused on this question. So we couldn't have a better panel to discuss these questions. Let me quickly introduce our three panelists and then give them an opportunity to tell you a little bit about the work that they're doing on this critical issue right now. So first, we're going to hear from Jennifer Holmes, who serves as assistant counsel at the NAACP Legal Defense Fund. She works on cases that advance racial justice in the areas of educational, equity, economic justice, and voting rights. Jennifer was part of the litigation team challenging the law that was passed by the Florida legislature that tried to undermine Amendment 4 that would have that grants voting rights to the formerly incarcerated and former felons. And she's also been trial counsel on behalf of a coalition of Harvard students and alumni groups in the Harvard litigation involving affirmative action in university admissions. She also helps develop LDF lawsuits that promote fair housing and economic security to strengthen communities of color, and has authored amicus briefs that were filed in the US Supreme Court. I'm also delighted that we are joined by Kevin Morris, who is a quantitative researcher with the Democracy Program at the Brennan Center for Justice. His work focuses on voting rights and elections, so we're really glad to have him here as well. His research focuses really on the impact of laws and policies on access to the polls, with a particular focus on rights restoration and voter list maintenance. He's also a PhD student in the sociology program at CUNY Graduate Center. And we're also delighted to be joined by Nicole D. Porter, who is Director of Advocacy at the Sentencing Project. And she manages the Sentencing Project state and local advocacy efforts on sentencing reform, voting rights, and eliminating racial disparities in the criminal justice system. Her advocacy has supported criminal justice reforms in several states, including Kentucky, Missouri, California, and she's been named a new civil rights leader by Essence magazine for her work to eliminate mass incarceration. So as you can see, we've got the star panel to deal with the questions that we're going to be asking today, which is really how incarceration affects the exercise of voting rights. So what I'd like to do is to ask each of our speakers first to tell us a little bit, kind of quickly, succinctly, what work you're doing, with a special emphasis, of course, on how incarceration has affected the voting and political rights of the individuals with whom you work. Let me start with Jennifer Holmes from the Legal Defense Fund. So why don't you tell us a little bit about the work that you've been doing on this front? And please turn on your mic. Thanks.
It wouldn't be a panel without someone attempting to speak while they're on mute, right? So I guess I better be the first one. Well, thank you so much for having me. Thank you, Professor Harcourt, for that introduction, and Christina and Maggie for coordinating this panel. I'm delighted to be here. I'll just give two examples of some of LDF's work that has to do with incarceration and political rights. I'm so happy that you're hosting a panel on this topic, because a lot of times we think of incarceration as just a criminal justice issue, but it really intersects with a lot of important other civil rights areas, such as voting and political participation, as well as economic justice in terms of employment and getting housing, and also education. We always talk about the school to prison pipeline. So it's crucial to see these issues as intersectional. So I'd like to briefly touch on two cases. I was part of the litigation team in Florida, as you mentioned in the introduction, that was challenging a law that was passed by the Florida legislature that undermined Amendment 4. Now, Amendment 4 was passed by Florida voters. It was a ballot initiative passed in 2018 to end Florida's practice of permanent felony disenfranchisement. And many of us may know already that felony disenfranchisement often has a very racist history. Many states put it into place as a means to undermine Black voting power in the period after Reconstruction, including Florida. And it had both the purpose and the effect of really diminishing Black voting strength in those states that enacted those restrictions in their laws. For example, before Amendment 4 was passed in Florida, 1 in 5 Black voting age persons in Florida were unable to vote because of a felony conviction. And 1 in 10 of Florida's population generally was unable to vote because of a felony conviction. And Florida alone was responsible for 1/4 of disenfranchised persons due to a felony across the entire United States. So they really had a very, this policy had a very broad effect on limiting the voting power of citizens, and in particular Black citizens. And so in 2018, the voters ended this policy with Amendment 4, which passed with almost 65% of the vote. So that means it had bipartisan support. It was not an issue associated with one party over the other. However, in 2019, the Florida legislature passed SB 7066, which required that people with felony convictions had to pay back any fines, fees, court costs, or restitution associated with those felonies before they could actually vote, basically eviscerating the power of Amendment 4. And so that's what we sued. That's the law that we challenged in court. Unfortunately, to make a long story short, last month the 11th Circuit disagreed and dismissed our case on appeal. So now the law tacking fines and fees onto a person's, or making a person's right to vote contingent on fines and fees, is still in place in Florida. And so now what's left to do is not to fight so much in the courts, but through organizing, donations, and trying to get this law repealed through political means. I know a lot of people have donated to funds to raise money to pay off people's fines and fees. We also need to engage in education so people know that these resources are available, and also people know that some of their fines and fees might not be disqualifying. For example, ones that are associated with a misdemeanor, or ones that were tacked on after they were sentenced aren't disqualifying. So we are still fighting this case through education and through organizing, and we won't stop until we can really bring political power to people, returning citizens in Florida. I know you said succinct, but I just want to touch on one other case that LDF is doing because it relates to this issue, even though it's not about voting, and that's the issue of prison-based gerrymandering. LDF filed a case in February in Pennsylvania under the Pennsylvania State Court, under the Pennsylvania constitutional provision of one person, one vote, challenging the practice of prison-based gerrymandering, which is counting for redistricting purposes incarcerated people in the district where they are incarcerated rather in their home district. This artificially enhances the political power of areas where prisons are located, which are usually rural, which are usually white, and it saps political power and funding from home communities that are usually urban and Black and brown communities, and often the places where people return to upon reentry. And so that case is still ongoing. It's in the early stages, but I just wanted to bring that up as another non-voting, but certainly related to political rights area that we're working in.
And just very quickly, what's the legal grounds for that?
It's based on, it's a state constitutional challenge saying that prison-based gerrymandering violates the Pennsylvania Constitution's one person, one vote provision because it's artificially counting people in the place that is not technically their residence and their home. And for many of these people, they will be released back into communities, and it's not like any associated funding that might go where they've been redistricted because they were incarcerated. Those dollars don't follow them back home. Once they've been redistricted and counted as part of the prison population, the money is placed in the prison district rather than in their home districts, even if later those individuals are released back to their home communities.
Right. Great. Thanks, Jennifer. Great work. And we'll come back to those two cases, and I'll actually try and give you a little bit more airtime because I know you need to leave at 1 o'clock. So, all right. Kevin, do you want to tell us a little bit about all the work you're doing at the Brennan Center, please?
Yeah, happy to do so. Fun to be following Jennifer because she hit on a lot of the things that I wanted to talk about from a slightly different perspective as well. It'll be a good panel because we've got people working on very similar issues and doing different parts of the fight. So, like Jennifer, the Brennan Center is pretty involved in the Amendment 4 case going on in Florida. We do, at the Brennan Center, we are a legal policy think tank, which means that it's a whole lot of attorneys and then a couple people doing social science, political science research as well. I'm one of the lucky ones that gets to do the political science research. So it is interesting thinking about Amendment 4. Jennifer just brought up kind of the racial disparities, of course, going into Amendment 4 being on the ballot, and then coming out of it in Senate Bill 7066, which is the law that we're all suing to overturn. And we'll see if that actually ends up happening. But we ran some analyses early in 2019, about 6 months after the amendment had been passed, to see who had actually taken up the opportunity to get registered after coming home from prison. And we showed that about half of the folks that came home from prison and then registered to vote were Black, identified as Black on their voter registration form. And just about 13% of the state itself identifies as Black. So we know kind of who these disenfranchisement policies are affecting because of great work from folks like the Sentencing Project and their Lost Millions reports and things like that. But we also have some evidence of who's going to take up the opportunity to get re-enfranchised, who's going to get on the rolls. And so we know that when the state and the legislatures are enacting laws like this, they have really racially disparate impact on political participation. One of the things that I did want to hit on is, as of the end of this summer, we're actually, we hit a major milestone in the United States. And it's not as major as we'd like, but it's one milestone on the road to the full end of disenfranchisement. And that is that with Iowa ending permanent disenfranchisement for all formerly convicted individuals, there are now no states left in the United States that permanently disenfranchise all residents convicted of a felony. Now, it's got a lot of caveats. All formerly convicted people everywhere permanently. There are a lot of states that that permanently disenfranchise some people. Florida is one of them, depending on the severity of the crime that was committed. But we are now no longer, does any state carte blanche disenfranchise everybody. So we're kind of in this moment where we want to celebrate that win and then also redouble our efforts as we're moving forward. And there are lots of efforts ongoing right now. If anyone here watching is in California, Proposition 17 is on the ballot this fall, which will end disenfranchisement for folks that are on parole. So everyone that's come home from prison will have the right to vote. So even in blue states, red states, you name it, there are only 2 states in the country that don't disenfranchise anybody. So all around the country, there's work to be done in all sorts of communities. And then finally, I want to touch on what Jennifer hit on with the gerrymandering. Some of my work that was published earlier this year shows kind of the spatial patterns in New York City of who gets disenfranchised, what communities are home to the disenfranchised population. And to folks that know the first thing about criminal justice, it's not surprising that disenfranchisement is concentrated in a few communities, generally lower income and minority communities. And so when we think about kind of the political representation, which voters are being removed, voters from what communities are not allowed to vote for mayor or vote for city council, and what that means for local interests, even at the sub-city level, disenfranchisement has a lot to say and has a pretty big impact on whose voices are heard even within their local communities. And then finally, and this is kind of the next fight, or where we want to look next, is there are lots of spillover effects, and we hit on this. Some of the panelists were chatting a little bit before we got started, and hopefully we'll get back to this conversation. But there's a whole heck of a lot of research showing that folks get socialized, and their identities as citizens gets really changed by their interactions with the carceral state and how they understand themselves as political agents. And so there's growing evidence that even when we restore voting rights to folks that were previously disenfranchised, getting them to turn out is tough, and getting politicians responsive to the needs of that community is really hard. So not only do we need to be fighting for the end of formal legal disenfranchisement, but we also need to be paying a lot of attention to how do we actually reincorporate these people's voices into our body politic.
Great. Thanks so much, Kevin. And I'm going to come back to some of these things, and particularly the effect on elections, and whether or not we think how much we think it's going to tip elections, and some of the research that was done by Matza and Eugen a few years ago. So great, thanks so much. Nicole, why don't you tell us what you're doing at the Sentencing Project and all of the efforts that you guys are doing there?
Yeah, thank you for the introduction, Professor Harcourt, and it's great to be on a panel with Kevin and everyone this afternoon. So I work at the Sentencing Project, which is a bridge organization between the Academy and the activists, and one of our priorities is around felony voting rights. So there has been a lot of change, and I think the comments from the two earlier panelists have brought out a great deal of information already. So I'll just add that even though disenfranchisement in the United States has been specifically racialized following the Civil War, building off of Jennifer's comments earlier, the practice did predate the Reconstruction period, although certainly felony was used as a proxy for Blackness as states reconstituted themselves following the Civil War, and continues to be used as a proxy for Blackness as a function of disenfranchising tens of thousands of residents. And it's extremely severe in southern states like Georgia and Texas, where people in the community on probation and parole are disenfranchised, and there are literally tens of thousands, hundreds of thousands of residents, mostly young Black men, who are disenfranchised because of a disqualifying felony conviction that may have landed them in jail or prison for a period of time, but for the most part, they live in the community and are marginalized from the electorate because of that felony conviction. And where I think this is going, the movement to end felony disenfranchisement overall and expand the franchise, given the changes we've already heard about today, from Amendment 4 in Florida to Proposition 17 in California that Kevin mentioned, and hopefully will be overwhelmingly passed by the California electorate. There's a great deal to be done in terms of expanding the franchise to people in the community who are on supervision. There was a lot of movement in the mid-2000s following the 2000 election. By my count, since '97, 25 states have changed their sentencing laws and felony disenfranchisement laws. In particular, we've already heard about Iowa, Florida, hopefully California is next. Last year, New Jersey, Colorado, Nevada all expanded voting rights to people in the community. But there are there's over 20 states that still need to expand voting rights to people on parole and probation. And that would be the next area of reform. And like Kevin suggested, blue states, including California, hopefully that will change in a few weeks, but also Connecticut, New York, need to expand voting rights to people in the community. Now, it's important because given what Kevin said earlier around the change in Iowa, it is true that the Iowa governor issued an executive order expanding voting rights to people post-sentence, but the underlying law in Iowa hasn't changed. And so lawmakers and the electorate need to actually fix that, as they do in New York, where even though Cuomo a few years ago issued partial pardons for about 35,000 residents on parole, restoring their voting rights, the underlying law in New York hasn't changed. So there's a lot of work to be done. And much of that work can happen with folks in the community in the states that disenfranchise people on probation and parole. There's also work to be done to expand the franchise to people in prison. Kevin mentioned that Maine and Vermont are the two states that never disqualify anyone from voting with the felony conviction. The District of Columbia actually expanded voting rights to people with felony convictions earlier this year. So there's two states in a district. And then also Puerto Rico also allows people in prison to vote in that US territory. So there have been credible efforts to expand the franchise to people in prison in the last few years. So in addition to trying to enfranchise people in the community, supporting efforts around that will hopefully help to build momentum and create more activity and more engagement. When the District of Columbia expanded the franchise to folks in prison, we sent out a notice from the Sentencing Project and got a lot of encouraging responses from directly impacted and formerly incarcerated people. So I hope that the recent change in DC can help spur other efforts around the country. And most recently, there was a credible effort in New Mexico where legislation passed out of the state Senate but got held up in the House that would have expanded the franchise to everyone in the state, including people in prison. So I'll stop there and look forward to getting into the dialogue with Jennifer, Kevin, and in the audience as well.
Great. Thanks, Nicole, and thanks for all the great work, all three of you. I mean, you're doing such important work, and we all are so grateful to you. I mean, this is one of the rare areas in kind of the fields that we all toil in, where you don't have to make the argument of racism and inequality so much in felon disenfranchisement, because I mean, even the United States Supreme Court recognized it themselves, right? And you know, if you look at the famous case of Hunter versus Underwood, which anyone who's interested in felon disenfranchisement, really, you've got to read. It's just an amazing decision by the United States Supreme Court. It was from 1985, where they basically invalidated the disenfranchisement provision of Section 182 of the Alabama Constitution. But they go through and they really, they use the language of the legislators who were passing the Alabama Constitution in 1805 and who were specifically saying in clear terms that the whole purpose was to disenfranchise Blacks, and the way in which they were changing laws and which laws they included. So by contrast to some other areas that we all toil in, this one, at least there's a clear statement even by the United States Supreme Court that this has this legacy behind it. And so, Nicole, thanks for talking about some of the history. It's really important. Florida has always been at the center of so much of this, as you were saying, Jennifer, because 25% of the population of the folks who were disenfranchised were in Florida. So we saw the change in Florida, and then we saw the legislative reactionary reaction there. First of all, just quickly, Jennifer, is the case still, is there a cert petition that's pending, or what's going on in terms of the 11th Circuit decision? Or is there a rehearing petition, or where does that stand exactly?
So there's no cert petition or rehearing petition at this time. We're still within the window to file a petition for cert. And so we're just weighing all our options. The litigation team is weighing all our options about whether to do that, considering the status of the court right now.
Yeah, right. The court's not that promising. What about, and neither is the 11th en banc, but yeah.
Yeah, and the 11th Circuit opinion that came down was en banc. So,
right. Right.
Really rehearing, we skipped the panel stage and went straight to en banc. So rehearing isn't really an option.
Right. Okay. So, all right. So what about the other efforts? Tell us a little bit about where we stand. There's a lot of media attention, some mention of Bloomberg spending some money down in Florida to pay off people's fees and fines. And there's been a lot of contributions and donations and stuff. Where does that stand now in terms of how many people have been able to, use some of those funds?
Well, it's hard to know the exact numbers, but I should note that yesterday was the registration deadline in Florida. We know that at the time that we tried this case back in late April, early May, there were 85,000 people with felony convictions who had registered pursuant to Amendment 4. And we don't know how many of those individuals may or may not have fines and fees. So we know that certainly people had been taking advantage of Amendment 4 up to April or May of this year. And I am confident that many more people have. This, of course, is still a small fraction of the estimated 1.4 million people who were re-enfranchised under Amendment 4. And I think that speaks to a couple of issues. It's very difficult. Outreach and education are crucial parts of getting formerly incarcerated people engaged in the political process. Many people still assume that if they have any contact with the criminal justice system, they cannot vote, which is not true. It's not a categorical ban in any state, as we just heard. And so efforts at education are crucial. There are also, in Florida, are many groups such as the Florida Rights Restoration Coalition and LeBron James' group called More Than a Vote that have raised money to pay off people's fines and fees. So I know that they've had some success in contacting people, engaging them, paying off fines and fees, and helping them register. But obviously there's a huge gap between 85,000 and 1.4 million. So that speaks to how much more we have to do with organizing and engagement.
Right. Yeah. So, and 85,000 are those up to date, or is that kind of back in May? I mean, so in other words, it just closed. So we don't know.
That was back in May.
That was back in May. Okay.
I don't have the up-to-date figure.
Okay. Kevin, you're the quantitative expert here. Do you have any more information for us on Florida and how that's going, or?
Yeah, we know that through the summer, folks were registering. As the decisions came down from the 11th Circuit, it seemed to maybe have a slight chilling effect, unsurprisingly. One of the problems with doing any of this work and what some of the lawsuit centered on was just how difficult this data is to actually get. It's hard to get counts of who owes how much and how much they owe. And where they are. So we have some data that we work with from the state that list the folks that have come home from prison, but Florida also permanently disenfranchised anyone that was convicted of a felony probation, sentenced felony probation. And so it's tough to get our hands around that data. Dan Smith at the University of Florida has done a lot of really great work on this, and he's got a lot of those numbers. I'm guessing Jennifer's numbers were pulled from Dan Smith. He filed an expert report in that case. But yeah, it's tough to get the most up-to-date numbers, but hopefully we'll be able to do something coming before the election.
Yeah, in terms of the numbers, I mean, some of the great work that had been done by Jeff Mattson and Chris Hugan back on the Bush-Gore election had effectively shown that Florida was one state where it would have possibly tipped the presidential election, and definitely tipped some of the senatorial elections back then. I mean, do we have any? I mean, it's impossible. Well, we're gonna. I don't know. We got Nate Silver on a panel in 2 days. If you all want to tune in with the Holder Initiative, talking to Eric Holder and some other folks. So I know it's up in the air, but how much do we fear that disenfranchisement can affect the 2020 elections, by contrast, say, to the way in which we believe it had affected the 2000 elections, if you see what I mean?
Yeah, yeah. So the work by Jeff and Chris is great. Jeff was actually, he advised my master's thesis. And so we go back and forth on this a lot. They get a huge amount of credit for starting this conversation, and their work was really groundbreaking. Tracy Birch at Northwestern has also kind of updated some of their analyses and found some of the assumptions. So I think it's definitely, I mean, we're definitely seeing big representational impacts, but especially in the case of Florida, so many people are convicted of felonies in the state of Florida. The bar for felony conviction means that the pool of people that are convicted is really large and crosses partisan divides. We've seen lots of Republicans supporting Amendment 4 and supporting the registration drives because they know that this affects their communities too. I think that to the extent that if we think that ending felony disenfranchisement is going to be a major boon for one party or the other, A, we're missing why we should care about felony disenfranchisement in the first place. And B, I think that we would be disappointed. I think that there are just so many people that are caught up in the criminal justice system, and sure, it falls along racial lines, but the partisan lines aren't as clean and clear as a lot of folks might think right off the bat.
Well, can I just jump in there?
Yeah,
I think that, so the criminal justice system in the United States explicitly does imagine Blackness at the center of it, and that is why there's such a disproportionate impact on Black communities in particular. But because the criminal justice system is so punitive, it also catches up white residents in it as well, which explains why, even though there is a disproportionate number of Black residents who are disenfranchised and also sentenced to, very extreme punitive sentences in the U.S., that there are also a large number of white residents who, despite the assumptions that Black residents vote blue, there's more mixed assumptions around what white residents who might be justice involved and who they might be voting for. I think also the experience of the criminal justice system, this is something to explore and to study, has an effect of distancing Black justice involved residents from the two political parties who, there is quite a lot that both mainstream political parties, have done a lot to lean into tough on crime rhetoric and reinforce punitive sanctions, not just around felony disenfranchisement, but also around the punitive laws that get people caught up to begin with. So there's quite a bit of anecdotal evidence out of Wisconsin, and even in interviewing, newly registered voters, Black voters in Florida, that what is known about the Democratic Party, from the early 90s, and a lot of sort of misperceptions around the causes of growth of incarceration, but despite any misperceptions or misunderstanding of sentencing policy, there's a general narrative that, the 94 crime bill contributed to a growth of incarceration, and many Black, newly enfranchised Black voters in Wisconsin and Florida assigned blame to the Democrats, which does not make them strong Democratic voters. So there is the justice involvement in and of itself has an effect of distancing residents from formal participation in civic life, not just in voting and connection to any of the mainstream political parties, but also other aspects of civic life as well. And we did get into this a little bit before our panel discussion started. It has an effect of sort of de facto marginalization from other aspects of civic life that would hopefully bring people back into voting. For example, in Florida, in Miami-Dade County specifically, there's been an establishment of rocket dockets to help process people through, to help pay off those fines and fees. And despite the large number of volunteer pro bono attorneys to support processing people through, that very few residents in Miami-Dade have actually gone into court and sought out that pro bono support in order to satisfy or satisfy the conditions of their court cases so that they could, in fact, register to vote.
Yeah, no, that's entirely right. Yeah, and Nicole, and I mean, so in other words, the issues are much larger than just the electoral, than just the election itself. And I think that I think it's Amy Lerner and Vesla Weaver who did a lot of work on that, trying to talk about the larger democratic impact, the larger participatory democratic issues, kind of bringing people into the debate, and all of the issues that you were putting on the table, which is entirely right. Yeah, I mean, one can't be limited simply to also a bipartisan election, basically. I mean, a two-party election. That's right. Now, Nicole, in terms of, we were talking about the change. I mean, most of the change we have seen has been in one direction, right? In other words, when we think about, in the death penalty context, we often talk about evolving standards of moral decency, which was the way in which the United States Supreme Court was able to get rid of the death penalty for juveniles, or the death penalty for persons with intellectual disabilities. Is that there's a movement in one direction. It is the case, right? That is it or not? Has the movement been predominantly in favor of enfranchisement? Could we say in the United States? I mean, do we think that there is an evolving standard of moral decency here?
Yeah, I mean, I think predominantly the movement has been towards enfranchisement. So I think, yeah, we could characterize changes since the late 90s in that way. There have been a couple of outlier examples, though. One in Massachusetts in particular, where Massachusetts used to be a state where people in prison could vote, but during the early 2000s, a group of incarcerated, imprisoned residents organized a political action committee, with the goal of, or mobilizing their social and political capital and working to influence an electoral race. And because of that, the state actually worked to disqualify people in prison from voting. But yes, you're right, overwhelmingly the changes since the late 90s have been towards enfranchisement, not to disqualify residents with justice involvement from voting.
With some reactions like in Florida, but generally the trend, favorable trends, yeah.
I do think there's a lot of de facto disenfranchisement. So even though the underlying policies are there, it doesn't mean that it's easy for residents to vote. And so we can get into, I mean, that's very weedy, and we can get into the nuances in that, but Florida is a cautionary tale where the electorate voted in one way and then the legislature came back and restricted it. And then who knows going forward what onerous practices will be adopted with the goal of, oppressing the vote or suppressing the vote going forward.
Right. And now, how many states allow persons who are incarcerated? Is it two states who allow persons who are incarcerated to vote? Or
well, this is where I'm going to get technical with the distinction between incarceration and imprisonment. So if we talk about incarceration, I include people in jail in that category, and then want to be clear with the audience that people in jail, if they're pretrial, and in most jurisdictions, if they're sentenced to misdemeanors, they can vote. Now, when we talk about prison, so imprisoned residents voting, 2 states never disqualified individuals from voting. Those include Maine and Vermont. And the U.S. territory of Puerto Rico actually allows people in prison to vote, and that history goes back to the 80s. And now the District of Columbia expanded voting rights to people in prison as of July of this year. So there are 2 states, a territory, and a district that allow people in prison the right to vote.
Okay, yeah. So there's a whole other frontier to fight. But Jennifer, so it was interesting that you were talking about the prison gerrymandering, prison-based gerrymandering, which is really another big issue here. So as we think about these issues, is that in a way the next frontier, or what are the next frontiers? I mean, I think, okay, we're gonna continue talking about, you know, enfranchisement here in this panel. But just as we look to the future, what are the other frontiers that need to be kind of?
I do think prison-based gerrymandering is one of the next frontiers. It might be somewhat patchwork though, because I think these claims are stronger brought in state court. The Supreme Court has not been all that amenable to various gerrymandering challenges,
Right.
except like, on occasion racial gerrymandering claims.
Right.
So it may vary state by state. I also think another area is lawsuits based on whether the state or locality is adequately facilitating the rights to vote that it is already put into law. So Nicole was mentioning that many states allow sort of pre-trial people who are detained pre-trial to vote, but are they actually facilitating that? Are there any sort of structures that enable people to request a ballot or even in some very, very small instances, you know, have some sort of polling place in a jail. And I think often the rights are there, but are not being facilitated in any sort of sufficient way. So I think that is also the next frontier to make these rights real and go beyond being just something on paper. I think currently that issue kind of smashes headlong into COVID concerns. We actually have
I wanted to bring that up. Like, how is COVID affecting all of this, right?
Right. I mean, so many jails and prisons are COVID hotspots. Yeah. We have a case in Arkansas where we've sued. It doesn't have to do with voting, but just we've sued and brought a 1983 claim alleging Eighth Amendment violations because of the abject failure of the facilities to protect incarcerated persons from contracting COVID. We also have a case in South Carolina that is not specific to prisons, but our client is an organization run by doctors, and their typical practice around elections is to go into jails and help people who are detained pre-trial vote, which is something now they're not able to do. So I think, you know, sort of the first step is actually striking down laws that categorically bar people from voting, but now we really need to get into actually facilitating those voting rights even during a pandemic.
Yeah. How have you seen, Kevin, COVID affecting kind of the work that you're doing and such? Yeah.
I mean, I think one of the big ways, and this kind of intersects with like voter purge work that the Brennan Center does, is that when folks are convicted of these felonies and when they come home, they have often been removed from the rolls. They usually have been removed from the rolls. In some states, they get a flag that can get removed. But all of the normal ways in which voters register to vote in advance of a presidential election have been really hampered this year. When we think about people going in person to the DMV to get registered, when we think about community groups sending people out into neighborhoods where we know that folks that have been to prison are more likely to live, all of these ways of getting people kind of knit back in are really being hampered. And especially, I mean, I was looking at the numbers from Florida recently, but we know in a lot of different states, the number of registrations have just dropped off a cliff this year. And we know that the folks that are most likely to be getting registered on any given year are folks that are a little more peripheral to the political system. So precisely the folks that we want to be bringing in, precisely the folks that we want to be turning out, maybe for the first time since they got home from prison or since they finished their felony probation, they're not able to get on the rolls this year. The normal conduits for doing so have been really ruptured. And it remains to be seen what impact that's going to have. You know, Florida registration, the books closed yesterday. It's kind of, there's not a whole lot that can be done on that front at this point, unfortunately.
Right. Yeah. I mean, you know, I suppose, I mean, COVID and all of the implications of COVID essentially act as just another hurdle here, right? Another cost, another form of resistance, of stickiness that obviously when there's already difficulties to vote or difficulties to be enfranchised, et cetera, it just adds this additional layer that is gonna be extremely unhelpful in these times. Yeah, Nicole, Jennifer, you had mentioned that you're gonna need to leave at 1 o'clock. So I wanted to just kind of give you, an opportunity for some last thoughts before we continue the panel with Nicole and Kevin. In terms of also what can people who are listening to the panel kind of like, how can we all support the work you're doing?
Sure, thank you. I think, one thing we just keep coming back to is the importance of outreach here. And there's a huge gulf between what the laws may be on the books and whether someone who has contact with the criminal justice system can actually and knows they can actually engage in political participation, whatever that, whether through voting or other means. There's studies that show that voting is often sort of the first step in getting people more civically engaged more generally, and those are habits that get passed down to their children. So all the more reason to try to bring in people into kind of the body politic in this way. And so I think engagement on the ground is crucial. So if there are ways you can participate in voter registration activities, especially ones that might be geared towards people who have had contact with the criminal justice system, those are crucial. I think it's also important for people to kind of get schooled on what the actual status of formerly incarcerated people's voting rights is in their state. The fight doesn't stop with ending the barrier to permanent felony disenfranchisement, but knocking down all those subsequent barriers. We also have to remember that for some people, the right to vote is important, but it's not nearly as pressing as some of the other needs in their life, some of the important economic struggles that they may be going through that are exacerbated by having a felony on their record. And so if you're going to engage people, you need to engage people beyond just registering them or talking about voting, but in ways that they actually feel like address their immediate needs as well as their kind of civic needs. So those are sort of my thoughts about how people can get more involved. If you are interested in learning more about our cases, you can go to naacpldf.org. But I really think an important part of it is making sure to connect with groups on the ground who, re-entry groups or people that have these direct contacts to people coming out of the criminal justice system.
Thank you so much, Jennifer. Thanks for joining us. And
thank you for having me. Sorry I had to run early.
That's all right. That's all right. You got a lot of work to do. And thanks for all the work you do. All right, we'll continue the conversation. Kevin, you were telling us about California, Proposition 17. So that's so I want to find out from you and Nicole. First of all, we've got listeners and viewers across the country now because we're all remote and Zoom and virtual and whatnot. And I know a lot of my students are in California, zooming into class that way. So I want to find out about what's going on in California, but I also want to find out where else are there going to be important propositions on the election in November that people should be paying attention to, because we've got people scattered everywhere. So first of all, Kevin, and then maybe Nicole, you can also jump in on that one. So what's the situation in terms of Proposition 17? What does the polling look like, and where do we stand right now?
So happy to have a little bit of good news. The polling looks really good in California right now. It only needs 50% to pass, and it's been right around 60%. So it looks like it's going to get through. I will take the opportunity when we're talking about Prop 17, and I'm sure that Nicole will join me on this, but there are big carve-outs there. And this is one of the things that we see all around the country, is that when people go to re-enfranchise formerly incarcerated and formerly disenfranchised individuals, that we hold on to some of our punitiveness. So in the case of California, if you've been convicted of a sexual offense, you won't be re-enfranchised. We saw the same thing in Florida. If you were convicted of murder or a sexual felony offense, you didn't get your voting rights back. So even in these places where we have, we're racking up wins, and we are going to re-enfranchise a whole lot of people that are living in the community. We still hold on to some of the punitiveness, even after these folks have finished their term. You know, the judge, the court said, this is the punishment for your crime, and we choose to continue to punish them, even after they have finished that sentence, even after they've done what the court said they needed to do. And so we kind of condemn them even past the end of their sentence. Nicole also hit on this in terms of what's important on the ballot this fall. I know everyone and their mom is watching the presidential race and so focused on the US Senate and are the Democrats going to lose the House or keep the House, but so much of this is local. So much of disenfranchisement policy is set by the different states. So Nicole was talking about Iowa, you know, making sure if this is something that you care about, making sure that the folks that are running for your state legislature are going to support the constitutional amendment that's going to be coming before the Iowa legislature. Similar to here in New York, I'm in Brooklyn. We need Cuomo to, he passed that executive order, he signed that executive order back in 2018, but the legislature needs to codify this. And this isn't a theoretical argument. We saw this happen in a number of states. We saw Iowa, a former governor signed an executive order re-enfranchising people, and then a new governor came in and ended that. The same thing happened in Florida. 2 governors ago, they had really pretty robust re-enfranchisement policies, and then that went away because it wasn't passed into law. It was just an executive order. So making sure that you're paying attention to local races, paying attention to who's running for your local state house is really, really important. It's not as sexy, it doesn't get covered in the news as much, but so much of our criminal justice, and particularly our voting laws, are set by groups within a given state. So those are some of the most important races to watch. And then of course, I'll also just add, this has less to do with voting, but DAs, your local district attorney, has a huge amount of influence over criminal justice policy. So paying attention to local races, I think, is the most important thing that we can do from a political perspective.
Right. Yeah. Because I mean, like, I'm going to turn back to you, Nicole. But as Nicole, you were saying, right? I mean, it's a pipeline issue, right? I mean, it's not just dealing with the disenfranchisement and enfranchisement. It's also who's getting prosecuted, how many people are getting prosecuted, et cetera. Nicole, so what are the hot spots as you see it for the November elections, but also for this time? Like where should we be focused? I mean, what are the things that people around the country, in addition to paying attention to local elections and DA elections, et cetera, should be thinking about on this topic?
It's great to be hear the latest numbers on polling out of California. It's really encouraging, and I hope Proposition 17 gets adopted next year. Connecticut will have active legislation that's built off several years of working to expand voting rights to people on parole. So if California does it this year, then hopefully that'll lead Connecticut to do it next year. And then, the last 2 blue states that have those voting bans are Connecticut and New York. So I would hope that there's a serious effort in New York as well, building off of Kevin's comments around, it's great what Cuomo did, but also the legislature needs to do something in terms of codifying that policy. Mm-hmm. So, there are no other ballot measures that I'm aware of that would affect and expand the franchise to justice involved residents on the ballot this November, but there are active efforts to address de facto disenfranchisement, building off of what Jennifer said before she had to leave. So even though people on paper have the right to vote, clearly there's de facto disenfranchisement happening, particularly for incarcerated residents who might be in jail on election day. And, let's be clear, someone could get incarcerated the Friday before election day. And if they are registered to vote but happen to be in jail that day, they most likely will have missed any absentee ballot deadlines and will be de facto disenfranchised unless there are other practices in place that ensure their access to the ballot on November 3rd. So what people can be doing now in November even though there aren't any other ballot measures or other hotspots that would actively expand the franchise, like there are out in California, is to get involved in jail-based voting efforts to ensure that people have access to the ballot if they are incarcerated. So they can find information about this at Tenancy Project's website, where we have a bunch of resources, and we're working regularly, weekly, with active campaigns in Texas, Illinois, Massachusetts, around ensuring that at the local level, people will have access to the franchise, even if they happen to be jailed on November 3rd. So we want to invite folks to get involved, you know, between now and then. As a resident who's following these issues, you could reach out to your sheriff or county jailer who's in charge of running your local jail and ask if, particularly if there isn't an active coalition effort around what they're doing to ensure access to the ballot on November 3rd for jailed residents.
So let me actually get more specific on that. I mean, at a place like Rikers, say, for New York City, how do you vote if you are in jail? Is it absentee ballot? Or, I mean, should we be working towards actually having polls in jails? Are there any places where there's actual polling in jail so you can actually vote in jail in person?
There has been a move in recent years in Cook County in Illinois, where Chicago is, actually has sort of led the charge on this. A couple years ago, a state law was passed, building off of Kevin's comments earlier, where, you know, some of this is a state policy, but that state law requires counties of a certain size, of which Cook County, Chicago would have been the only county to fall into this category, that required a polling location at the county jail. And there was actually a polling location in the March primary earlier this year. The challenge is obviously in the context of the pandemic. In the Cook County jail.
Yeah.
There was a polling place in the Cook County jail, yes. There's also polling places in other local jails around the country, but not statutorily required, at the discretion of the sheriff or the jailer. So for example, in Los Angeles, in one of the county jail facilities, there is an actual polling location in that county jail in the March primary as well, or in the earlier primary this year as well. And there's been efforts to get polling locations in other county and local jails around the country, including an active effort in Harris County, Houston, where there's support by the county commission and the Democratic sheriff, but there is hangups in terms of implementing it. But there's an active effort to get it done, and maybe for November, but if not for this November, for future elections as well. So that is a new frontier, trying to get polling locations at local jails.
Okay, and barring that, you would have to do is absentee ballot, right? Which, I mean, is incredibly difficult in the prison. I mean,
and onerous because of this work that we're doing around jail-based voting. Some of the requirements for absentee ballot, and you know, the entire country is going through this because of the effort to expand absentee ballots or mail-in voting given COVID. But in Oklahoma, for example, in order to vote by absentee ballot, you actually have to have your ballot notarized. And so to, you know, ensure access to the ballot for jailed voters, and to meet that requirement around having it notarized, is something we're trying to engage directly with city and county officials on. But that is a barrier. That's a significant barrier to overcome for the jailed voters in Oklahoma City.
Right. Yeah. No, it seems. I mean, that seems as if that should be a right. I mean, that's probably another frontier that we really need to work on, which is actually getting polls in jail, because persons who are in jail are not convicted of anything. You know, I mean, so there it would seem as if clearly we need to make a huge effort to kind of completely transform the way we think about that, to provide for the right to vote in a pre-trial detention facility. going back, okay, so I'm going to actually start. So we've got some questions that are rolling in, and we don't have that much more time. So let me try to bring in some of the questions that are coming in from some of the folks who are listening in attentively. One of the questions is, how do you respond to those who argue that disenfranchisement is justified for certain crimes? So this goes back to Kevin, your point about the fact that there is still this kind of punitive remainder in many of these states, and even in some of the favorable propositions and legislation where they do nevertheless restrict it for someone convicted of murder or someone convicted of a sex offense. So how do you respond to those who argue that, yeah, well, it's justified in certain crimes, or maybe and maybe not in those crimes then, but maybe in some other crime, or might there be one such as, I don't know, some kind of public corruption or something like that, where, what's the response to that? Someone is asking who's listening in.
Yeah, I think that's a great question. I think I'm not 100%, but I think Virginia is a good example of what you're talking about, where they permanently disenfranchise anyone that's been convicted of electoral fraud. That's about the only state that I can think of that has permanent disenfranchisement actively tied only to election offenses. I mean, I'll go back to what I said before. Folks will say, we do focus groups and polling and that kind of stuff, and people will say, well, they committed such a terrible crime, they should continue to pay the price for it. And we just say, well, listen, this is, if they committed such a terrible crime, they probably were in prison for longer, putting aside personal beliefs about like how good that is, but like the state already has mechanisms set up for punishing people and in varying that punishment based on the severity of the crime. Mm-hmm. I think it is the idea that there should be permanent disenfranchisement for some people. Honestly, it makes me a little bit sad. It reflects a really impoverished view of people to think that, if we let someone who's been convicted of murder vote, that suddenly the country is going to fall apart, or that we're going to be electing murderers to our highest offices. That reduces the folks that have been convicted of these crimes to one mistake that they made. And it may have been a really big mistake, but to say that someone is entirely irredeemable as a citizen, their voice doesn't matter at all, we don't think they have anything worth saying in the public sphere, because of a crime that they maybe committed 20, 30, 40 years ago. That to me is, and I think to hopefully a lot of the people on this call, that's a sad way of thinking about people. It's a sad way of thinking about redemption and forgiveness.
But I think, I think you make the strong argument. You make the strong argument that really this is a form of punishment, right? Not being able to vote and to exercise your civil and political rights is in itself a form of punishment. So it shouldn't be kind of, in some way, it shouldn't be tacked on to a sentence. Now, we might imagine that, I don't know, there could be some legislation that provides that part of punishment is this determination by a judge sentencing. I'm a punishment abolitionist, so I'll put aside my own views on this. But one could make the argument, say, but there's a way in which this is imposed above and beyond the punishment. But so it's a form of punishment that's kind of meted out by some other entity than the sentencing judge. And I think actually the same argument you make, Kevin, could be an argument against the Virginia code you were mentioning, which is about even election fraud. Because if the punishment for election fraud is 5 years or a fine or something, then that's the punishment. In other words, or if part of the punishment is you can't vote anymore, then that would be part of the punishment. But it doesn't seem equitable to have both, on the one hand, punishment, and then on the other hand, this thing that's added on top of it.
Right. And Nicole said this earlier, but it predates Reconstruction. It predates the Reconstruction Amendment, and it actually goes back to English common law, this idea of civil death. Civil death is something that the English wrote about a whole heck of a lot, saying that you are effectively dead to the body politic. You are irredeemable.
Right.
And that's what we're telling people when we take away
Right.
their voting rights, certainly when we take them away forever, but even when we take them away temporarily.
Yeah.
And let me just add, so in the United States in particular, which laws were led to disqualification from voting were specifically racialized, even though that history around English common law, but certainly following the Civil War and during the period of Reconstruction. And this is clear in the Constitution, in the in the adoption of state constitutions, like in Alabama, and you mentioned this earlier, Professor Harcourt, that it is clear that the writers of that state's constitution specifically used certain laws as a way to disqualify Black residents from the electorate. So, you know, specifically, the crime of murder was not a disqualifying felony from voting in Alabama, but wife beating was, because of the assumption by the writers of that provision that convicted wife beaters were more likely to be Black, would be Black. So that history underlies this policy in the United States that distinguishes the US from other Western countries. And when we address felony disenfranchisement and also consider that some laws may be worthy of, you know, permanent disenfranchisement, or others have to also, you know, reference the broader context and the broader history around that in this country.
Yeah.
Specifically.
Yeah. And I mean, that everybody's got to read Hunter versus Underwood. Everybody's got to read it. I mean, that's just essential reading, it seems to me, for any kind of citizenship on these issues. Let me ask you, we got another question about the Supreme Court, which is interesting. Now, obviously, we have a conservative-leaning Supreme Court. And so, to what extent can the United States Supreme Court intervene on these issues in terms of ballot issues and ballot initiatives? Or is there a way in which, like, the Supreme Court can only act favorably, not negatively, on an issue because it's such a question of kind of state law, election law, if you see what I mean? In other words, do we have to, what's the concern? Is the concern with the Supreme Court that they're not going to be helpful, or that a conservative Supreme Court is not going to be helpful, or is it going to be positively unhelpful, if you see what I mean? Kevin?
Yeah, I mean, I'm not an attorney, so this is a little bit of just conjecture here. I mean, I know, because I've been involved with our litigation in Florida, that there's a lot of nervousness about taking that up to the Supreme Court because they might uphold the 11th Circuit's decision.
Yeah.
I do think, I mean, obviously, or I shouldn't say obviously, in the United States, election law is so localized. It's usually run at the county level, if not your town level. States have some input. The federal government has some, but a lot of it is dictated at the local level, at the state level. One thing that your question made me think of is how HR 1 intersects with this. HR 1, or the Democracy for the People Act, was passed by the House in early 2019, and it would end felony disenfranchisement for anyone living in the community in federal elections. I think that we can imagine the Supreme Court having an opinion on whether or not federal government can interfere. I don't really know, though. I mean, I think more broadly speaking, they have the ability to uphold bad things more than to overturn bad things.
Right. Is that your sense of it too, Nicole? Is that your sense of it too? I mean, is this a ratchet, or is it or what do you think?
Oh, I too am not an attorney, but I will say that I think where the movement on this is, and you know, Jennifer said this in her comments before she left, is on organizing and helping to shift the standard in the United States towards universal suffrage, full voting rights for all. And we can start with expanding the franchise to people in the community. That is the next big category. of residents who are disqualified from voting, people on felony, probation, or parole. Hopefully California will be next with Proposition 17, and then working down the list to help expand the franchise and the overwhelming number of states that continue to disqualify people from voting if they're under community supervision. And then hopefully extending the franchise to people in prison and, supporting credible efforts in the short term where that's possible. So as a non-lawyer who has no faith in the Supreme Court, given the changes, recently, and, who knows what will happen over the next couple of weeks. But, my focus is with the activists and organizing and helping to expand the category of states that are enfranchising residents who are justice involved.
Right. Okay. All right. Well, let me address the question a little bit then, since I'm the only lasting remaining lawyer on the panel or something. As a lawyer and as a law professor who knows entirely well that all law is just politics, I would say that I think that there is a ratchet in the sense that it's not as if the United States Supreme Court can disenfranchise itself. In other words, it can't engage in the kind of state level decisions about electoral politics and qualifications in that way. And so it actually, it can be helpful if there are claims of like one person, one vote or something like that. But I doubt that it can be affirmatively negative. It can also not, obviously it can also, uphold a bad decision like the 11th Circuit. I mean, the 11th Circuit en banc decision on Amendment 4 is an abomination and it's an injustice. It's just horrific. I mean, how those judges could write that opinion is shocking, right? And of course, the United States Supreme Court could very well uphold that. So obviously they wouldn't be helpful there. But I do feel that from a constitutional perspective, it is a bit of a ratchet in that sense. Now, someone did ask in the chat, and I think we've put it in the we put it in the chat function. I'm not sure what was the case that I was referring to, and the site for the case, and it's Hunter versus Underwood, and it's 471 U.S. 222, 471 U.S. 222, a decision from the United States Supreme Court in 1985. And when you read it, you really get a sense of what this whole disenfranchisement effort was about, which was disenfranchising African Americans. I mean, it was clearly the post-Reconstruction effort to recreate an apartheid racial hierarchy in this country. There's no doubt about it. Okay. Anyway, we've got some.
I mean,
go ahead.
Richardson v. Ramirez would also, I would add, has to be kind of the counterpoint in terms of Supreme Court decisions. In which the Supreme Court affirmatively upheld felony disenfranchisement and said that it was constitutional. So I don't want, lest we give anyone the idea that the Supreme Court has been uniformly good on this issue.
Yeah. No, but I think that the Hunter piece just shows the history of what disenfranchisement is about. I think you're entirely right that that as a constitutional matter, it's not unconstitutional to have disenfranchisement, which is the other case. But to get that sense of the history and the racial history, it's an amazing case. Quickly.
I mean, I was going to quickly add that, similar histories can be looked at in other states as well. So for your students or anyone curious, I mean, similar histories can be explored in Louisiana, Mississippi, and of course, we've been talking about Florida, but also Virginia. So if folks are curious about that, there's a lot of research to be done, and there's also resources that can point people, to those root issues. Great.
Do you have that on your site, on the sentencing project?
Yes, there are resources available on our website.
Great. So everybody should go there. Okay, well, we've got now that the questions are starting to roll in, but of course we're getting towards the end of the time here. One of the questions has to do with kind of like a separations of power issue, in the sense that one of the questions has to do with, do you think that there is a political motivation to re-enfranchise felons? And so there's a political dimension to it. And then the follow-up question that is being asked there is, should the courts, and not Congress, Senate, the president, et cetera, because there is a conflict of interest, should the courts be the ones who get to decide these questions of enfranchisement, et cetera, which is an interesting.
Such provocative student here.
Yeah, no, it's an interesting question, right? Because it goes precisely to that issue of the potential politicization of these, and it's funny because I mean it also flips the kind of constitutional political question exception upside down, right? Because it is political. Usually the courts often will kind of like withdraw using a political question exception to decide the cases. But so we've got a lot of questions rolling in, a lot of great questions, which means that obviously the conversation has to go on. But we only got 1 minute left, really. And maybe I'll just throw out the last question for you each to respond to, which is probably the most important one, which is, what can those listening today do to help with these issues? So what can those listening today do to help you, Nicole, with your work, and then Kevin with yours? Nicole?
Yeah, and I will invite folks who had questions to reach out to us, and we can continue the discussion maybe on the Facebook page, but also folks can feel free to email me directly at the Sentencing Project, just staff@sentencingproject.org, and it will get to me. But right now, again, focused on jail-based voting and ensuring the franchise for people who are going to be in jail leading up to Election Day. So there are active campaigns. People can email me at that email that was just shared, and I can connect you to any state or local campaigns that are happening in your state. And then going into 2021, building off of hopefully Proposition 17 in California, we'll have new campaigns to expand the franchise to people in the community. I know that there's active efforts in Connecticut, hopefully New York. Kevin will have to let me know about that. And then other active efforts in Georgia and Minnesota as well. So, join us, because there's a lot of work that needs to be done in terms of expanding voting rights to people with justice involvement.
Great. Kevin?
Yeah, I mean, I'll echo a lot of what Nicole said. If you're in California and you want to do some phone banking, there's a lot of that going on right now. We can connect you with folks doing that work. I would say, again, I'm going to go back to what I said earlier, paying attention to what's going on in your community. So to the extent that Nicole hit on this, there's a lot of discretion over how absentee ballots get into the jails and whether or not there can be a polling place. So calling up your sheriff and calling up your local elected officials and say, this is something that I care about and I'm paying attention to this. I'm paying attention to how easy or how hard you're making it to vote for folks that are in jail or incarcerated. And then finally, this is harder to do with COVID right now, but it's going to be important going forward, is joining registration drives, volunteering to go out and register people in communities that are marred by felony disenfranchisement, that are marred by mass incarceration, and really supporting the groups, both financially, that are doing the work, but then also getting out there with your labor and getting people registered and getting them on the rolls. We've talked a lot about the rupture of that citizen identity. So get out there and help people feel like their voice matters. Say, I want you voting. I want you being part of the decision making that's going on in my community. I think that is really, really key. So
great. Thank you, Kevin. Thank you, Nicole. This is really one of the most critical issues facing us as a nation, I think, because it goes to, it ties to the problems of mass and racialized incarceration and the consequences of that, and the devastating consequences and effects on racial injustice. So thank you, Kevin. Thank you, Nicole, for all of the work you're doing on this. Thank you, Christina and Maggie, for setting up this fabulous conversation. It's been really spectacular. You put together an amazing panel. And so we really owe you a great debt of gratitude, as well as to Jennifer, who had to hop off a little bit early. Christina, you're going to tell us about the next events you've got coming up?
Yes, thank you. Thanks to all four of you for such a dynamic conversation and for all the work that you do. I would like to flag the two remaining panels as part of the series. One is Indigenous Peoples' Rights in Elections, which is October 14th. And the other one is Human Rights Classrooms and Elections, teaching the day after the election. which is October 16th. And both of those, the first one, the Indigenous Peoples' Rights will start at 12:10, and the second one will start at 1 p.m. So thank you all for joining us. We hope to see you at the next one. And thank you again to our moderator and our panelists.
Great,
Thank you.
thanks. Take care.